Hello, good evening, everyone. Thank you very much for joining us for this webinar on our supplementary consultation paper as part of our Contempt of Court project. You will know that this supplementary consultation paper has arisen following the concerns raised in the Southport attacks. I will come on to that in a moment. I just wanted to take a brief moment to introduce those of us here. So my name is Nicholas Hoggard. I'm one of the lawyers on the Contempt of Court project and a lawyer at the Law Commission. I'm joined by Lawrence McNamara, who will be dealing with the Q&A and marshalling those, and also by Miles Wright, one of our research assistants, who is dealing with the tech because I am incompetent in matters tech. So thank you very much indeed for your engagement with this project. We had some really constructive engagement both before our original consultation paper was published and also in the form of formal consultation responses to that paper. So for those of you who have submitted consultation responses to that, thank you very much indeed. But thank you also for attending this webinar. Your engagement with the project is really appreciated. These are difficult and nuanced issues. And so we are very grateful for those with experience and expertise in contempt. We will publish these slides on our webpage. We are also recording the event, and so we're going to post the recording of this on the project webpage. Hopefully the slides and recording will be available in the next day or so. We'll let you know by email. The next 3 slides will explain what we aim to do in this webinar and more prosaically some housekeeping and what we'll cover. So next slide, please, Miles. The plan then is that we will explain some of the issues that we have addressed in our supplementary consultation paper. I should say that supplementary consultation paper is available on the project webpage if you haven't read it already. The idea is that this webinar will assist you in responding to that supplementary consultation, and especially in explaining how it relates to the main consultation that we ran last year and explaining some of the issues that have attracted interest recently and or are contentious. There will be an opportunity, as I intimated earlier, to ask questions using the Q&A function. But fundamentally, most importantly, we hope that you will give us your views in a consultation response to this supplementary consultation. This supplementary consultation closes on the 31st of March, and information about how to respond is on the project webpage. If you have already responded to the main consultation, then, and if you feel you have no more to add to that, then you don't need to respond again. We are in the process of analysing all of those responses, and so there is no obligation to repeat yourself. However, if you have something further to add that is on the topic of the supplementary consultation, then we would be very grateful for that. And the fact that you have already responded to the consultation shouldn't disbar you from doing that. And indeed, it may be that you've revised your view in light of some of these issues. Just some housekeeping, if I can have the next slide, please, Miles. As I've said already, the event is being recorded and it will be posted to the website. Your microphones and cameras are switched off for all attendees. If you have a question, then please post it to the Q&A. It will be reviewed by our team before it is then published to the thread. Given the time constraints, we may not publish everything that's on the Q&A. That is to say, we may not publish on the thread everything that's submitted, or it may not happen immediately, especially if, for example, we might be dealing with an issue that arises later on in the presentation, or is not directly relevant to the supplementary consultation. But we will take account of everything that is submitted using the Q&A. Finally, please don't use the raise hand function. We don't have the technological ability to turn it off. That's a comment on our tech, not on our individual abilities. But we will lower any hands that are raised. So please just limit yourself to the Q&A function. I should also say that the expectation is that this will take no more than an hour. We've given ourselves an hour. In fact, it may well take less, depending on the volume of Q&A. The recording, just to confirm again, will be available afterwards. So we're joined by a number of people live now, but our expectation is that this will be watched subsequently by people as well. That's the preliminary matters out of the way. So I wanted to start just by placing the supplementary consultation in context. Miles, if I could have the next slide. The contempt project is looking at the whole field of contempt. This is a small, very important, but nevertheless a small part of it. We ran a consultation on our consultation paper between July and November of 2024. And we published this supplementary consultation paper on the 3rd of March. The reason we did that was because we were asked by the Home Secretary, the Attorney General and the Lord Chancellor to expedite the part of our report that deals with liability for contempt and some of the Attorney General issues. I'll come on to the details of that in a moment, but the effect of that is that we will be publishing the report in two parts. So part one, dealing with liability and some Attorney General responsibilities, will be published in the autumn of this year. We will then publish the rest of our report, my apologies, in 2026, and that will be dealing with remaining matters such as the powers and protections that are afforded to courts and tribunals, procedure, and so on and so forth. We will not be dealing with the remaining matters in this webinar, nor indeed will we be dealing with many of the matters that would arise in part one. We are just focused on the issues from the supplementary consultation paper, which are a couple of issues that have been brought into stark relief following the Southport attacks, and particularly the public disorder that followed thereafter. In terms of what will happen for legislation, just so that our role in this is clear, we may or may not be asked to provide draft legislation. Sometimes the Law Commission is asked to provide draft legislation. We will obviously update you on the plans for that. So in any event, our timeline for reporting remains. The question then is whether we produce draft legislation ourselves or whether that remains a matter for government to do in time. I will just, for the sake of, as I said, the supplementary consultation webinar is not about the main context of contempt, but nevertheless, I think it's worth putting in some context I'll start again. It's nevertheless worth explaining where this issue sits within the broader field of contempt liability. Miles, if I could have the next slide, please. In our consultation paper that we published in July, we proposed disposing of this slightly anachronistic distinction between civil and criminal contempt. Instead, we proposed a simplified form of, or at least clearer form of contempt liability. This framework involved three strands. So there was general contempt, which was, if you like, the main form of contempt, the broad form of contempt that included general contempt by publication other than when proceedings are active, and general contempt by conduct other than publication. So that includes a lot of things that we would currently think of as being contempt in the face of the court, things that are interfering in the administration of justice before the court. It also includes other things, but that's the sort of stereotypical example of that. Secondly, we propose two further specific strands. One is contempt by breach of orders or undertakings. That is slightly broader than the existing civil contempt category, but nevertheless adopts much of the framework and the elements of proof from the existing form of civil contempt. And then thirdly, we proposed a form of contempt by publication while proceedings are active. We have, and it is within that third category that the supplementary consultation paper sits. The issue that arises here is what can be said when proceedings are active that does not or should not attract contempt liability. I don't propose to go into much detail on the general forms of contempt. It is nevertheless worth dwelling on the contempt by publication whilst proceedings are active, given that that is the framework against which the supplementary consultation sits. So, Miles, if I could have the next slide and the one after that, if possible. Thank you very much. So we proposed a framework that is very similar to the existing rules on contempt liability when proceedings are active. Now, in the criminal law, what we mean by proceedings are active is from the point of arrest. The Contempt of Court Act 1981 sets out that liability. This is often called the strict liability rule. Liability is strict in the sense that somebody does not need to have intended to risk seriously impeding or prejudicing the course of justice. And that's what we see in this first part here. Conduct may be treated as a contempt of court as tending to interfere with the course of justice, in particular legal proceedings, regardless of the intent to do so. But that rule applies only to a publication which creates a substantial risk that the course of justice in active proceedings will be seriously impeded or prejudiced. There are some defences. Miles, if I could have the next slide. So the person, publisher, so somebody who publishes material will not be guilty of contempt of court if at the time of publication he does not know and has no reason to suspect that relevant proceedings are active. Further, if they are a distributor, so that they haven't published the material but are nevertheless distributing material that other people have published, then they will not be guilty of contempt of court if at the time of distribution he does not know that it contains that matter, so that the matter that would have a serious risk seriously prejudicing or impeding the course of justice. We provisionally proposed, Miles, if I could have the next slide. As I say, we proposed this, the same conduct element. However, we said that the fault element should be more explicit. The form of contempt that we propose is strict liability in the sense that you still don't need, if you're a publisher, to be shown to have intended or foreseen that the proceedings will be seriously impeded or prejudiced. But we do say that it is only right that it should be shown that the publisher was at least reckless as to whether proceedings were active, which is to say that they were aware of the risk that proceedings were active and it was nevertheless unreasonable to take that risk. For a distributor, so a distributor who may be distributing many publications, we say that the threshold should be slightly higher. So one, that they were reckless as to whether distributed material created a substantial risk that the course of justice in proceedings would be seriously impeded or prejudiced. So for distributors, the fault element does speak to the consequence, whereas for the publisher, the fault element speaks only to whether proceedings were active or not. As I already mentioned, in the criminal law, which is really what we're talking about here, that's not to say contempt is criminal law, but the issues that have arisen in Southport relate to criminal proceedings. They apply, they are active from the point of arrest. We do have a consultation question from the main consultation paper as to whether that should change. I'll probably mention this later in any event in the context of Southport, but in case I don't, it's probably worth flagging that, of course, in the case of Southport, that question is slightly moot, given that the point of charge happened so soon after the point of arrest. But nevertheless, we do have a question to which people have responded helpfully on that in the consultation paper. Miles, if we could move on to the next slide. So the context in which these contempt issues arose. As I say, we were asked to conduct, to expedite part of our report by the Home Secretary, Lord Chancellor and Attorney General, in part because of the concerns that followed at Southport, the public disorder thereafter, and in particular, the perception that contempt of court rules may indirectly have stoked the public disorder by creating an information vacuum into which misinformation and disinformation could flow. It is not for the Law Commission to say one way or the other on whether the whether that causality is correct, whether the contempt of court rules in that particular case did create an information vacuum, but nevertheless, some interesting questions have been given renewed focus. There has been considerable public engagement on this issue. The Panorama documentary a couple of weeks ago rehearsed some of the things that we had heard subsequently in our consultation responses. Obviously, our consultation paper, having been published at the beginning of July, did not deal with the issues that arose in Southport because Southport hadn't then happened. By the time that people were responding to our consultation paper, it had. And so we've already had some very useful comments come in relation to that. There have also been a number of public comments, including from the Police Chiefs Council, from Counter-Terrorism Policing, from Jonathan Hall, KC, the independent reviewer of terrorism legislation and the independent reviewer of state threats legislation. There have been public comments from the Director of Public Prosecutions. This has also been dealt with in committees in Parliament. So there has been a lot of public engagement on this topic. We felt that given the renewed focus and given that our consultation paper didn't deal directly on this point, it was nevertheless, it was worth considering again with a magnifying glass some of these issues. So Miles, if I could have the next slide, please. There are two contempt issues that really arise here. The first one is, what does the test for liability actually permit? So we've said that when proceedings are active, you can't publish information that would carry a substantial risk of causing serious prejudice or seriously impeding the course of justice. Is there an argument that more can be said without meeting the threshold of serious prejudice or serious impediment? And I should say that they are two different tests, prejudice and impediment. They speak to two different things. From a fair trial perspective, they are both equally important. I think a number of stakeholders have said to us that, well, one, prejudice is maybe more important to protect than impediment. The ECHR might take a different view on that point, but nevertheless, it is worth bearing that in mind. From the Southport perspective, though, the question is, could more have been said? Whether it could have been said in that instance is not really for us, but taking the more general point, the more theoretical point away from the specifics of Southport, we have to think about whether the law can be clearer about what can be said. We should be able to consider whether there are more things, more clarity that can be afforded. The concern that has become obvious from some of the stakeholders is that there has been an overcautious approach. I can entirely follow that concern. The other concern that has been raised is that contempt of court is part of a suite of tools that exist to protect a defendant's right to a fair trial and to ensure that those who should be brought to justice are brought to justice in the usual way, without having either their rights to a fair trial impeded, or, as may result from that, them not receiving a trial at all. And so the counter argument to the overcaution is that the overcaution is necessary. But nevertheless, that's the first strand, what can be discussed within the existing framework of contempt. Secondly, should there be a defence that permits the publication of material that risks undermining a person's right to a fair trial if published for the purposes of ensuring, say, public safety or national security? This is slightly different from the public interest defence, so-called, that currently exists in the Contempt of Court Act, because that defence applies to public interest material that was incidental to proceedings. Of course, here we're talking about the publication of public interest material which is directly on point, that is not incidental to proceedings at all, but is very much about those proceedings. So what we would be considering is whether there should be a defence that is broader than the existing defence that permits that publication. We already proposed in our consultation paper a clarified form of defence. But what we said there is worth rehearsing. We cautioned in the consultation paper in chapter 5 at paragraph 132 that any defence that would have the effect of accepting that there is that degree of interference, i.e. that the publication risks seriously impeding or prejudicing a trial, and then permitting that interference would need to be carefully justified by consultees, especially where such an interference could affect the fair trial rights of a defendant in a criminal case. In this context, what we're talking about today, that question quickly distills to the more fundamental question, namely whether the law should permit the publication of material that risks undermining a person's right to a fair trial if material were to be published for the purpose of public safety or national security. There is also the cold comfort that might be afforded by having to run a defence at all. It is necessarily something that is considered after liability has been established, or if not established in court, then at least you consider, would we be liable? Answer, yes. And only then do you move on to consider, do we have to run a defence? The defence might be difficult to establish. We don't know. We haven't proposed a form of defence yet, but nevertheless, we're talking about potentially releasing material, publishing material that may relate to a trial that may be many, many months ahead. The nature of the defence may not be known. The extent of the risk may not be known. It may be difficult to establish in court what the public safety or national security concern was, and whether, in that sense, the light was worth the candle. So the defence is not a panacea necessarily to the problem, and anyone advocating for it, I think, would probably have to think how it would sit alongside the test for liability and what the test for liability might sensibly permit. There are further issues that we are not consulting on, and we will not be making formal recommendations on, but are nevertheless worth bearing in mind when we think about the risks that arise, the risks to the fair trial that arise when publishing material that would otherwise be in scope of contempt. As I said before, contempt of court is part of a suite of tools used to protect the defendant's right to a fair trial. Those tools include the judge giving directions to the jury, for example, and they include potentially moving the location of the trial if to do that would be to protect the fair trial rights of the defendant. It probably goes without saying that contempt exists at the extreme end of those rights, protecting or prohibiting, as it does, publications that seriously prejudice or impede the trial. That's not to say that things that merely prejudice or impede the trial are acceptable, but there are ways that courts can have of dealing with them. The contempt threshold is set to balance the right to freedom of expression on the one hand with the right of the defendant to receive a fair trial on the other. And so contempt naturally sits at the upper limit by focusing on the risks to serious prejudice or impediment. Nevertheless, if people were to argue that we should chip away, even for very good reason, at the protection afforded by contempt, then we might need to think about what other protections should exist, protections for fair trial rights. As I say, we will not be making recommendations on these, but these are things that may factor into your consideration of how we balance free expression rights with fair trial rights. So one alternative could be, and I stress we're not proposing this, it's outside the terms of our project, but you might say that a juryless trial would deal with the fair trial issue by removing the risk of serious prejudice, and that might be a better way of protecting fair trial rights than by using contempt. As I say, it's not for us to say, but it's difficult to consider contempt in isolation from the other factors that exist to protect fair trial rights. I'm aware of time. I've been waffling on, and I'm much more interested in the Q&A than hearing any more of me. So if I can ask Miles just to go on to the next slide. Just to reiterate that the supplementary consultation is available on our website. We will be posting the recording to our project webpage. And finally, Miles, if you could go on to the last slide, just so that everyone has it, although actually Google works very well in these contexts. The Law Commission website and the project page are there. So without further ado, then, I think it's probably best that we go on to some Q&A if there are any. And if there aren't, then I will say thank you very much indeed for those of you who attended. And as I say, we will be publishing the part 1 of the contempt paper in the autumn of 2025. That will include all strands of liability, so general contempt, breach of orders, and contempt by publication when proceedings are active. And that will also include this particular part on the supplementary consultation paper on the issues that have arisen from Southport.
Any questions?
Okay, so if there are no questions then that have arisen, then I will thank you all very much indeed for attending, and please do get in touch with us if you would like to discuss anything further in relation to this supplementary consultation, and failing that, we look forward very much to receiving your responses if you have anything further to add.